It's 1 o'clock. Shall we start? There are no objections. So welcome everyone who has joined us for this webinar organized by the Swiss Chambers Arbitration Institution and by ASA. We are graced today by the presence of two very well-known international arbitrators, Richard Harting QC and Crenguta Leaua, who will address us. Myself, I am Matthias Scherer. My official function at ASA is I'm the general editor of the ASA Bulletin, and I also sit occasionally as arbitrator, as many of you will know. Now, we have also Caroline Ming from the Swiss Chambers at the background, who will assist us. Now, let me introduce you properly to Richard and Crenguta. Richard, and I should say, these two speakers reflect very well the reach of ASA and SCAI, which is certainly that many international practitioners, as of today, are members or users of the Swiss rules or of ASA. So this is a very good turnout. Richard Harting, QC of Keating Chambers in London, studied Arabic and Persian at Oxford University and also in Egypt, and he was then called to the English bar. He specializes, as many of you will know, in disputes that have a link to the Persian Gulf of the Middle East. Many of them are construction disputes. He acts as counsel and as arbitrator. And his cases have related to a diverse range of projects, including airports, high-rises, marine structures, and even a theme park. He regularly acts as counsel also in cases in the and is the founder of and chairman of the Society of Construction Law in the Persian Gulf. As to Crenguta Leaua, she is an arbitration practitioner in counsel and arbitrator with more than 120 appointments in a variety of seats and institutions. She is the managing partner and the founder of her own law firm in Bucharest, Leaua, Damkali, Diaconu, and Paunescu. She's also a professor at law at the Bucharest University of Economics and in the LLM program of international arbitration of that very university. And as most of you will know, she is also a former vice president of the ICC court. And currently, and this is important for her speech, her presentation, she is a member of the board of the Silicon Valley Arbitration and Mediation Center. So certainly she's someone very well familiar with technical issues and solutions. We have discussed and decided that Richard will take the lead. He will address us on a topic which is very close to him: experts presentations, experts cross-examination, something that has maybe less been impacted by COVID-19, fortunately, but requires some additional skills, and Richard will tell us all about it. Please, Richard.
Thank you, Matthias. I think you're going to put me onto the full screen.
Here you are.
When you first invited me to join a fireside chat for Swiss lawyers, I wasn't really expecting to be sitting in my offices in London looking at a computer screen, but I'm very pleased and honoured to join you all, even if the circumstances are not quite ideal. So my talk, as Matthias said, is going to be about the use and misuse of expert evidence in complex international arbitration. COVID has caused us to rethink many things that we've always taken for granted in our lives and in our work. And I'd suggest we should be taking the opportunity to rethink the use of experts in arbitration. Experts are very expensive, sometimes even more than lawyers. And they create hundreds of pages of reports, appendices, annexes, exhibits. But how much of that really makes any difference? In my view, sadly, very little. I often find that my task as an arbitrator is to search through huge amounts of material to find the relevant bits. But why am I having to do that? Why have I not been given only the relevant bits? So my talk's going to be about how we can make the presentation of expert evidence more efficient. Now, the legal principles concerning expert evidence do vary a little between jurisdictions, but I'd suggest that the basic problem is really the same everywhere. And this is how I summarized it for a recent talk in the United States. Too many lawyers think they can just subcontract all the difficult stuff to experts, but they should really only be giving their opinions on matters that require not what happened or what the contract means. The leading UK textbook, Keating on Construction Contracts, has expressed a similar view in more learned terms in every single edition since 1991. The editors have said there is a regrettable tendency for expert reports in construction contracts litigation to contain inordinately long statements of hearsay fact coupled with inadmissible factual opinion. This should be avoided. In other words, experts' reports, particularly in construction cases, usually include large amounts of factual material and opinions on these facts. That really isn't expert opinion. And that applies not just in litigation in the UK, but in arbitration throughout the world. So what can be done about this? Well, let's start with some first principles. What is expert evidence? Here's the definition. It's from an English court in 1782. The opinion of scientific men upon proven facts may be given by men of science within their own science. In essence, that is still entirely accurate, apart from a bit about men. But let's look at that in a bit more detail. Expert evidence involves opinions requiring expertise, and not opinions which the arbitrators can properly form without assistance. It needs to be some special skill or knowledge. And the expert's opinions must be based on facts. The expert needs an accurate factual basis for his opinions. And the facts relied upon by the experts must be proved in the usual way by witnesses and or documents. Because experts generally can't prove themselves the facts they rely on, except perhaps in relation to experiments they might perform. Because usually the expert is engaged well after the project or transaction has been completed, and they almost never have any direct knowledge of what happened. Therefore, they can't give evidence about it. Similarly, an expert can't draw inferences from the facts and conclusions on the facts. All too often, expert reports include implicit assessments of the credibility of witnesses or the credibility of documents. That's obviously not for an expert witness to express the view on whether the oral evidence of a witness should be believed and accepted by the tribunal. But the same applies to witness statements. An expert can't provide a report on the basis that one party's witnesses are telling the truth and the other side's witnesses are not. We take that a step further to documentary evidence. An expert obviously can't give an opinion on whether the contents of any particular document is true. But he also can't decide on the truth of a series of documents, and therefore he can't give an opinion on the truth or accuracy of the story set out by a set of documents. That's the job of the lawyers to argue and the tribunal to decide. And where the factual position is not clear, it's not the job of the expert to draw inferences and fill the gaps in the story. That is something that the tribunal must do based on the factual evidence and the arguments of counsel. But despite those things really, when set out in that way, being quite obvious, many expert reports deal at huge length with disputed facts. And that, in my view, is a waste of time and money. It results in overly long reports that are very expensive to produce, and they're so long they're not properly read by anyone. It then takes a lot of expensive hearing time to work out why the experts' opinions are different. And far too often, the only real difference is in what the experts think happened. In other words, in relation to the facts, and nothing to do with expert opinion at all. So what should experts do to avoid these sorts of problems? Well, when an expert writes his or her report, the facts are either agreed or disputed. And if they're disputed, they have to be proved. And it will be the tribunal ultimately who will decide on those disputed facts and what actually happened. Therefore, the expert, when writing the report, has to work on the basis of assumptions. as to what facts will be found by the tribunal. And he or she must provide alternative opinions based on alternative assumptions about the disputed facts in order to be helpful to the tribunal. In other words, the expert will say, if the tribunal finds X, then my opinion is A. But if the tribunal finds Y, then my opinion is B. And 9 times out of 10, if the experts made the same assumptions of fact and law and provided alternative opinions, those opinions would be the same. They're not really arguing about matters of expertise, but about the facts. That also brings us to the law. Law is obviously not a matter for experts, unless they're called as experts on the law. And no technical expert would dare to give an opinion on a decision of the Court of Appeal or a Court of Cassation. They would recognise that as the law. But all too often they give opinions on what the contract means without regard to any legal principles. Or more subtly, they say a party has failed to do something. But saying that necessarily involves an opinion on whether the party should have done that, whether it had an obligation to do so, and therefore an opinion as to the meaning of the contract. Extending that a little further, experts can't reach a conclusion on legal entitlement. That necessarily involves issues of law. So it's wrong for an expert to conclude his or her report by saying that this party or that party is entitled to X dollars in damages. That is a conclusion of entitlement that he or she cannot properly reach. Just an example of this, I'm going to look at, for a moment, quantum experts. And this is the typical approach. You think about what's wrong. So here's a quote. The nature of my review involved carrying out a detailed analysis of the evidence in order to establish whether it substantiated the item claimed and the value claimed against that item. I conclude that the claimant has not substantiated this claim. But whether the person has incurred a cost is a matter of fact. He's either incurred that cost claimed, or a different cost, or no cost at all. And that is established from the documentary evidence and the witness evidence. It's not a matter for anyone's opinion. But quantum experts regularly say, well, I'm not satisfied with the substantiation provided. Well, if we translate that into plain English, the expert is saying he or she does not believe that the person making the claim has proved it. But proof is obviously not a matter for the expert, it's a matter for the tribunal. But here's the real problem. Isn't it just easier for lawyers to leave all the technical and difficult stuff to the experts? Well, yes, plainly it is easier, but what's the effect of doing that? First, the experts end up deciding their own scope of work, so they produce excessively long reports at great expense. Second, if the experts are left to work out what the client's case is and then present that in a report, that report's not going to be independent. Instead, the expert's simply going to be acting as an advocate. And you might say, so what? Isn't independence an English obsession in so many ways? But no. The question is whether the tribunal is likely to accept the opinions of an expert who is not independent. Remember, experts are there to give their opinions on matters outside the tribunal's expertise. So whose evidence is more likely to be accepted by a tribunal? The expert who is honestly assisting the tribunal with a technical issue, or the expert who is really only saying what his clients want him to say? And the evidence of an expert who's perceived by a tribunal as an advocate and not independent is very likely to be rejected entirely, which means that that apparently easy way for the lawyers, in fact, leads to disaster for the client. Experts can also deal with many issues which are helpful to the tribunal, even if not strictly matters which require expertise. For example, experts can agree what costs have been supported by documentary evidence. That's actually a factual exercise, but it may be done more efficiently by experts. These helpful exercises need to be very carefully controlled so they don't expand into a general review of everything that happened with a commentary on the quality of the evidence. And controlling experts is a matter for the lawyers. It's up to the lawyers to give the experts the right instructions, because the lawyers must distinguish clearly between fact and law and expert opinion. And they must then limit their requests and instructions to the experts on that basis, and that will save time and cost. But there is an important and I'd say essential role for tribunals in managing expert evidence. In my view, far too many arbitrators just let parties serve whatever they want, listen to whatever the parties want to say at the hearing, and then decide that 99% of the evidence that's been submitted is irrelevant. I suggest that the world of arbitration will be far better off with tribunals taking control earlier and focusing the evidence on what really matters. So the lawyers should identify issues which need expert evidence, but then the tribunal should check whether those issues really are appropriate, and should also check that both experts are addressing the same issues and on the basis of the same factual and legal assumptions. Of course, arbitrators need to take care not to be defining the parties' cases for them. But if a tribunal expresses the view that certain issues may not be appropriate, in my experience, it's very rare that parties still insist that their experts address those issues. So if you have a proper list of issues for the experts, it's then much easier for them to prepare useful joint reports which identify the reasons why their opinions are different. That will then provide focus for the hearing and the award. I'll just, in my last few moments, give a couple of examples of common problems with experts. Just think about this common problem that the quantum expert values a change in the scope of work at nil. That's possible, but rare. And what usually is driving that is the expert thinks that it wasn't a change at all. So what has gone wrong? Here what we have is a quantum expert who's dealing with liability. He says no liability, therefore nothing is due to the contractor. So how can we try and avoid that sort of problem? By the list of issues, clearly defining what are the quantum issues for the quantum experts. And also clear instructions to the experts to make sure they're basing their opinions on alternative assumptions. In other words, one assumption is the claimant's case on liability is right, and the other is the respondent's case on liability is right. One of those might give an answer of 0, but the other one is highly likely not to. I'd also suggest that one great problem with experts is joint reports. They can't agree a joint report and the parties go backwards and forwards, and eventually you end up with something that's of no assistance at all. And the reason for that is almost always because the experts are not focusing on the real differences between them in relation to expert issues. And they're basing their different opinions on different factual and legal assumptions, and usually ones that support the party who is calling them. So again, a clear list of issues will provide them with focus. They need to answer those issues only, and again making it their instructions clear about the assumptions on both sides' cases. And if they were to do that, I always tell quantum experts, I cannot see why you are coming to give evidence at a hearing. You should have given me, as the tribunal, alternatives on everything, unless there's some particularly obscure point about how you value a particular element of the work, and that is very much the exception. So I'll just end with these thoughts. Managing expert evidence in complex cases is not easy. It takes well-prepared and experienced people and well-prepared and experienced arbitrators to do it well. But if it is done well, huge amounts of money can be saved, and the award is far more likely to be a fair and just result. That's it from me. Thank you.
Thank you, Richard. Now for questions, as you may have seen in the chat, this goes to all those who are listening to us. You would have to frame your questions in writing. Please do so. We have a 5 minutes slot here to ask questions to Richard before we move to Crenguta Leaua, and then 5 minutes after her. If you have any, please write them in the chat box and they will be visible to either us or all of us if you address them to all. Richard, I do have one question in the meantime. Do you have any views or even experience about the situation that I seem to come across quite frequently. You may have experts on both sides. Ideally, not ideally, you have a good expert on one side and a bad expert or a underpaid expert on the other side. So there may be some imbalance there. But even assuming that you have good experts on both sides, at deliberation level, there may be technical issues that suddenly appear to be relevant, or you realize that you don't have answers or not answers from both experts on relevant points. Do you have any views of what the tribunal should or could do there? Like reconvening the experts with or without counsel, and how to make sure that the award is fair and reflects all technical issues that should be reflected, and just respect your process.
I think the first point is to try and avoid that sort of situation at all costs. So the better prepared the tribunal is in terms of having read the reports and understood the reports, and perhaps having a joint session with the experts, rather than just listening to what the parties want to cross-examine about. If you also have a chance to have both experts sit together and say, look, I've read this, I haven't understood it, can you explain it to me? That often works very well to deal with those sorts of issues that the parties perhaps haven't themselves properly raised and are concerning the tribunal. And yes, there's that further stage that once you've read further the closing submissions and discussed between the tribunal that you haven't perhaps understood some part of the technical evidence, do you reconvene the experts? I think that's going to be a last resort. What you can often do is ask for a supplemental report or a supplemental joint report. You can say to the experts, please, can you get together on the phone or by video and provide us with a joint report on this particular issue, on these factual assumptions. So on the basis that the claimant proves its case on this issue, how can you explain the technical point behind it? And then separately, the respondent's case. And you would hope that they would be able to produce a further and useful joint report on that basis.
So what you are saying, Richard, is I was not well prepared enough for my hearing. Otherwise, there would have been no need.
I'm sure you were, but many people. But I mean, to be quite.
I fully agree with you. You're right. The more that can be done at the hearing, when everyone is there, the better.
I'd emphasise the need to properly read the reports before the hearing, because.
Yes.
Afterwards,
and ask for supplemental reports sometimes, even before the hearing, or questions. There was a question I see now on screen. Maybe Richard, if you could address that, whether the COVID-19 regulations in the country, let's say it's a construction dispute, would be a change of law, and whether the contractor would be entitled to compensation of that on that basis. That certainly is a question that has occupied many contractors and owners' minds, and maybe you have seen something in the Middle East or elsewhere.
Yeah, that's potentially a huge question. I think we need to look very carefully at what guidance is being issued by governments and local authorities. Sometimes it's referred to as guidance, sometimes it is the law, and those will have different consequences, particularly if you have a contract that says there's compensation payable in the event of a change of law, but it's not actually a change of law. You wouldn't gain those rights. In terms of compensation outside the terms of the contract as a result of COVID, now it may well vary between jurisdictions, but generally it's very difficult, particularly in a construction context, because there's nothing that the employer has done wrong. There's no breach of contract. He hasn't asked the contractor to do anything different. So there's not a variation. So you really would be looking at some provision of the law in terms of adjusting the parties' rights and obligations as a result of force majeure or similar sorts of eventualities. Questions related to Geneva. I have, I'm afraid, no expertise.
I know you do a lot of FIDIC cases and construction law, so this is not only. Feel free to comment if in your practice you have come across these cases already. So shall we, are there further questions on this? I don't see. Okay, I don't see any more from the public, so maybe at this stage, should we move to Crenguta? Okay. Can you hear us, Crenguta?
Yes, can you?
Yes, so I did not yet introduce your topic. Your topic will be the use of software, different softwares, which has been accelerated by the COVID-19 crisis. And we all look forward to hear you.
Thank you, Matthias, and good afternoon to everybody which is now online with us. It's not easy to follow Richard's impeccable presentation, but I will try to do my best. Indeed, my topic today aims to address the impact of COVID-19 pandemic on the use of information technology, basically software in arbitration. Various restrictions were in place in many countries, preventing or slowing down the travel and transportation worldwide. Arbitration community had to adapt quickly, and the immediate effect that we all witnessed was a change in the in-person hearings towards online hearings, and the change, or rather relaxation, I would say, of the rules about the delivery of hard copies in the procedural communications towards electronic transfer of documents. This situation highlighted a number of issues that the arbitration world is confronted for a while now, but which became more visible nowadays. Being invited by SCAI and ASA to participate in this webinar, I thought to think about how the situation evolved. And in doing so, I will try to share what I personally learned from myself, and with the hope that this will be of use to the other participants to the webinar as well. The first problem is that the increase of diversity of arbitration practitioners is not yet paired with technological harmonization. Such a situation of nowadays, namely the COVID-19 pandemic restrictions, forced the quick adaptation of the arbitration practitioners to the modern means of communication, but also highlighted the diversity in stages of technological comfort for the practitioners worldwide. Few of us realized before that how diverse, in fact, the arbitration community became in the last 2 decades. We have now more than ever practitioners of all ages and coming from a variety of countries. That is excellent, but truth is that there is not much technological similarity of these arbitrators' backgrounds. Same goes for counsel in arbitration. Internet access, availability and speed is not the same everywhere. Familiarity with the modern technical devices is not the same everywhere, and so is the affordability. Softwares responding to various procedural needs are rather new, and not all practitioners are familiar with them or, again, afford them. Basically, we have nowadays 2 categories of practitioners. The classic practitioners and the technologically augmented practitioners, I would call them. The question that follows immediately is this a matter of competition only? I mean, services that are better provided by some people than others, or it may be an issue of fair trial or equal treatment too. This question is not new. Actually, it's at least 20 years old. If I would only quote the ICC Commission report on information technology in international arbitration, which was released in 2004, or among the doctrine, the wonderful study, which was written by Gabriel Kaufmann-Kohler and Thomas Schulz under the title, The Use of Information Technology in Arbitration, addressing this issue back in 2005. That both references, those of the ICC Commission or that paper, are quite extensively referring to the issue of the means and the tools to ensure fair trial and equal treatment. So what is new in 2019 COVID situation? I would say that what was before optional, now it became factually mandatory. So I've chosen my words carefully, maybe not legally mandatory, but factually mandatory. Basically, if you want a hearing to take place now, you simply must take the information technology road. The alternative may bring serious safety risks or implies an unknown delay in the proceedings. Therefore, it's no longer a matter of comparing what it is more or less efficient by using information technology, but we have a matter now of comparing the rights to be heard with the right to health in potentially life-threatening situations. So what I can learn from this, I ask myself. I think that firstly, I have to revisit an idea that was actually launched 15 years ago, namely to draft the arbitration agreements or to choose the arbitral rules in such manner as to make sure that they address the online dispute resolution. Like I said, this idea was launched 15 years ago, but I saw it in very little occasions implemented in practice. Secondly, I think that there is a need to clearly address the safety and health concerns. Such issue was rarely in the mind of drafters of arbitration agreements or rules, and I personally never saw it expressly mentioned in a contract. Perhaps this should change. It's a risk that is nowadays showing to have significant importance. One notes that numerous guidelines, checklists, protocols, etc. on the use of online dispute resolution were issued by the various arbitral institution or professional organization in the COVID-19 situations. To me, this is a signal of the need for such information. Basically, also a signal of the lack of proper training or discrepancy in the level of training of the arbitration practitioners worldwide before that. What I can learn from this, I ask myself. Well, I think that it is important now more than ever not to leave the training about the latest development of information technology for the last minute of emergency situation. This education is equally important with the legal education and should be part of our professional development as the continuous legal education requirement is. Now, also looking at the broader situation, the second problem that I identify is that the developments of many new arbitral institutions is not yet paired with the technological harmonization of the tools such arbitral institutions provide to their users. Surprisingly enough, or maybe not, it is not the largest or the oldest arbitral centers the one who invest the most in new technological tools, but rather the new institutions. The matter of investments in IT facilities was so far one defining the competitive advantage rather than addressing stringent needs of the users. What changed? Well, precisely this, the user's needs. What it was before a nice-to-have feature, it is now a minimum must-have situation. And problem is that if one develops IT solutions under an emergency situation, that there is little time left to test and properly implement such solutions. And obviously, this is not something to desire. So what I learned from that situation, well, I placed myself in various perspectives and I try to look at what can be done better in the future from different perspectives. From the institutional perspective, one can learn that investment in new technologies is a continuous exercise and should be considered a priority. From the Council perspective, there are a number of issues to think about, from which I chose only two. Firstly, that criteria of technological advancements of the arbitral institutions should be an important criteria in selecting the arbitral institution. This was not necessarily a criteria for the user's choice before. If we look at least at the studies that were published, for instance, those of the Queen Mary University, if you look at what criteria are ranked, the technological advancement of a certain arbitral institution is not mentioned there. Secondly, also from the perspective of the Council, I think that attention should be paid not only to this criteria. I mean, not only to the technological advancement criteria. We should introduce it, but I personally, I would also look at the proven stability, and I would say respectability of an arbitral institution, because that is crucial for the operability of the arbitration agreement. So that technological criteria cannot possibly stand alone. I'm saying that because nowadays it is sort of feeling, I would say rather an inflation of the feeling that technology is needed. Yes, it is needed, but it has to be complemented with stability and, like I said, respectability or proven activity over years of that arbitral institution with observance of the law and rules. From the arbitrator's perspective, I think that I've learned that I should be familiarized with the various tools available for the situation in which the arbitral institution provides little support in this respect. It may be that the parties will agree on such technical tools that they want to use, and I would only simply need to be prepared to use them. But it also may be that the parties would agree to use them, but they would not agree on the specific choice of one of them. And in the latter situation, I would be in the situation to need to choose, find the advantages or disadvantages of each of them and decide on the matter. That is indeed something important. The variety of the information technology tools in arbitration is much broader than simply audio and video conferencing. Indeed, these last two were those that were mentioned very frequently in the last months because they were in the eyes of everybody during the COVID situation. But I would like to remind that information technology tools in arbitration may be found in a number of other procedural situations. For instance, there are such tools for document collection, for reviewing and production of documents. There are softwares for management and transfer of arbitration data, platforms in this respect. There are softwares for presentation of graphics and evidence. There are virtual reality and augmented reality tools, especially used by the experts, and Richard has mentioned the importance of such evidence in arbitration. There are analytical tools and mind mapping tools that are used by those familiar with them. And there are, of course, as many of us have noted, translation and interpretation tools that are based on software. Many such tools are listed in a very useful guide, which is called Guide to Technology Resources for Arbitration Practitioners, published in 2019 by the IBA Arbitration Below 40 Committee, under the chairmanship of Noradel Ajay and André de Cavalcadi Abut. By the way, congrats for the idea. That was really timely issued, and I would encourage all of the audience to try to look at those references on the IBA guide, because they are really, really useful. I myself, at least, I've learned a lot from that. A third problem, and this would be the last that I would like to refer to in my presentation, is that of the awareness of responsibilities connected with the use of information technology. While the technological tools are indeed needed, they come with a number of potential issues, and those needs to be addressed legally. Firstly, I would like to mention the data protection requirements. Storing or transferring data needs to comply with the regulations concerning data protection. And here it was recently launched an international document of relevance, the ICA study in this respect. Secondly, the cybersecurity requirements. In this respect, we have also the ICA NYC bar protocol on cybersecurity international arbitration, which was released in 2019. Indeed, once again, a very timely tool. I would like maybe to stop here and note that arbitration was always ahead of the needs of the society in terms of how justice should be done in a better way than the classic way. So it is no surprise to see that the arbitration community has addressed issues of relevance immediate now with a little bit of time in advance Last year, 2019, was almost like a forecasting moment of the needs that were increasing in the year to follow, namely now in 2020. The last problem that I noted is the feasibility or issues related to the functionality of the chosen technical solution. The happy world in which technological tools are always working perfectly does not exist. Technical problems may occur, and not necessarily because of a cybersecurity breach, but because of intrinsic flaws of the system or power failures or other causes of technical nature. In all of this, the power of choice of technology to be used comes with an attached responsibility and possibly liability for such choice. There is a difference if the technology was the choice of the parties or imposed on them by the arbitral tribunal, or sometimes it is the choice of the arbitral institutions. In all cases, of course, the due process must be preserved. So I consider that, well, while there is a duty of addressing the technical issues and solving them as a priority, one should not forget that costs associated with this operation may be an issue open for debate. So we have a technical failure, we address it, we repair it. This will have some implications in terms of cost, the cost of that reparation or the cost of that remedy that has to be found, but also the delay of the proceedings. Some institutions understood this risk and already took some measures, and I refer here, for instance, to the AAA ICDR Information Security Program and the same institution's Business Continuity and Disaster Recovery document. But fact is that there is little awareness worldwide, and case law on this situation will surely evolve. I mean, cases addressing liability for the functionality of the technical support that is given to the arbitrators and the parties by those that decide the use of such technical support. That may be the parties, it may be the arbitrator, or as I mentioned, it may be the arbitral institution. And I would conclude by remembering that the Napoleon Civil Code had developed norms for the liability for the damages created by animals or things owned by humans. I would not exactly compare a dog with a software or a pigeon with emails, but one has to reflect on the potential liability for the choice and use of a specific automated system. I would leave you with this thought and hoping that my own lessons will be of help to you and my dilemmas will be helpful for avoiding your own dilemmas. I am now passing the microphone back to Matthias.
Thank you, Crenguta. Again, if people from the floor would like to ask questions, there is a chat function. Please use it. For my part, I would be interested in knowing whether you came across any software that assists arbitrators in drafting the awards. I'm only half joking. And second, whether among all those systems you have explored, you came across something that you would recommend. I mean, that stands out.
For me? Actually, the first question is a very good one, and all of us who are speaking and writing in languages other than English know the limitations that language softwares have in terms of the support tools for grammar, spelling, etc. in a variety of other languages. So this is, for instance, something very simple that is not harmonized. Not all the languages benefit from the same support in drafting from language perspective as English does. So we have a discrepancy here, and that is one thing to remember. We have a lot of jokes, each of us, and war stories about one tiny little word, absent diacritic or absent the specific accent that has to be placed on the word because of the spelling missing that error changes the whole meaning of the phrase. So that is the very simple example of where we have different situations that we are confronted nowadays. The second point as to a software that I would particularly recommend, well, actually, I'm not exactly looking at a software, but I'm looking at an initiative that I found quite interesting. It's called the Protocol for Online Case Management in International Arbitration. It was launched by a number of firms, working groups, the Legal Tech Department, and it is a consultation draft just released nowadays in July 2020. This is quite an interesting document because it has a lot of references to how the perfect online case management should look like, and what kind of logic it should embed, and where are the caveats. The document is open for public consultation for the next weeks, I think, until, at least if I saw correctly, end of August. And I would encourage the audience to look at it, because it gives an impression, at least, as to how the perfect world should look like. And then when you have a specific software addressing the online case management, you can at least compare it with this kind of list of desires that is presented there. And the second element that I'm trying to draw your attention with is an initiative that we launched at the Silicon Valley Arbitration Mediation Center just last week, about the type of needs that arbitration will have to respond for smart contracts, for the type of blockchain-based transaction platforms. So for those contracts that have an automized or an automized type of performance. And for this, we will need to adapt, and that means adapting from both sides, adapting from the side of providers of the arbitration services and adapters, adapting tools from the side of the users, from the side of those who are designing the smart contracts. Both of them are basically food for thought, both initiatives that I mentioned, and I think that at this moment we are, all of us, in a very intense learning phase. I've seen also two questions on the chat. I would try to respond to each of them. First one from Agnieszka: can you see any specific problems with online procedures that can give grounds for award challenge? What to avoid and what to be especially vigilant about while deciding about online procedure or while working on an arbitration agreement? Yes, I would see some problems that may occur. An online procedure needs to be offering equal chances to both parties. It's about equal treatment and fair treatment. And that means to make sure that the platform are functional in all the participants' country of origin. They are accepted in all such countries. There are some countries in which internet connection is filtered or limited, or in which the speed does not allow the use of all type of software. So we have technical limitation, and this needs to be taken into account. Exactly as many years ago we used to take into account how difficult it was to get with our correspondents to the next door, or with our correspondents to a remote island. The difference is that we don't have geographical challenges, but we have technical challenges and diversity. And as to where I can be especially vigilant, I would be especially vigilant to the type of softwares that would be at risk to violate provisions of the law, like data protection or confidentiality of sensitive information. These kind of situations might be particularly sensitive. A second question that I saw is from Pushkar Akbal. I have been reading about frauds, especially email and electronic communication. There have been instances of emails getting hacked, IP addresses can be disguised, etc. Yes, indeed, this is a concern, and this has been addressed, and I encourage you to look carefully to the ICA NYC Bar CPR protocol on cybersecurity in international arbitration. There is a 2020 edition to that. It's published under the ICA reports number 6. This is a document that addresses quite at length the topic. And the last question that I saw, I guess IT, especially emails, it's not really a foolproof way to be effective as against originals. There are limitations, but there are limitations in respect of fraud to anything. If you look at the paper we consider as, nowadays more valid or rather less subject to problems as an email communication. But there are frauds connected with paper as well. The history of law is full of them. I mean, we have in almost all civil procedural codes in all the countries provisions about the situation in which a document is contested as to its genuinity, when there is possibly about a fraud, tampering the documents, etc. So we are simply discussing about the type of environment in which the human will or the human consent is expressed, the paper-based document or the electronic document. In the end, it's about the environment that it is expressing the human will. But the problem remains the same, is or it is not the same human that we believe express its will that actually signed or that actually sent the document. The questions, basically, I don't think that we are facing new questions, new legal issues. What we are facing is new legal, new factual environment in which those legal issues needs to be addressed.
Thank you, Crenguta. We soon have to wrap up, so I would like to take this opportunity to take a step back, because what we have heard now and what we often hear is how to refocus on virtues and tools we have in arbitration, thanks or as a result of COVID-19. Now, what we should maybe also think of and consider is not only what COVID-19 does to arbitration, but what COVID-19 does to us, to you, as arbitrators and arbitration practitioners. And I thought about that a while, because we are a bit distracted by how hearings will look in 10 years, in 5 years, what software we will use, what parties there will be and what institutions. But what is equally important to us, or should be, is how the arbitration bar will look like in 5 years, in 10 years. Because one of the strengths we have in arbitration, and that distinguishes us from other professionals, we have a global network and we meet each other frequently and for a long time, for a whole lifespan of an international arbitrator. He will meet at IBA and other ASA, SCAI, and whatever other conferences or meetings they are organized. We have deliberations, we have hearings. So all this is affected by COVID-19. And I think whatever the next epidemic is called, it will affect us again, and it will affect the world as we know it again. And I'm not sure we will get back exactly where we are with all the meeting places we knew. So I wonder, and that ties my query a bit back to what Crenguta said about software, because I fear that there will be a lost generation of arbitrators. What makes us special, our relationship, is that we actually meet and we have physical contacts regular. We have to be respectful with each other because we will cross, our paths will cross as counsel or arbitrator. And this is cultivated over 5-10 years by regular meetings in different setups, professional and congresses or whatever. Now this is gone, at least for the time being, and I'm not sure whether it will come back. So what will this lost generation of arbitrators do? of especially younger arbitrators to replace what these meeting places constituted, opportunities to get to know each other, get to appreciate each other. What solutions will there be? Webinars, maybe with not set speakers, but everyone is expected to pop in, like the anonymous arbitrator, or how are there any software solutions there, or something that could help the arbitration community to stay as unique as we are now? And please, this is a question to everyone. Maybe Crenguta, if you have any good software that could assist, or good ideas.
Should I take, Matthias, that you are advancing the option of an arbitrator's Facebook, some sort of a platform? Yeah, that might be a good idea, because basically the generation of young practitioners nowadays, I mean the freshly graduates of these years, they have grown up meeting people and considering that friend is somebody that you are linked with on Facebook. So it's not the same definition of what a friend is in the dictionary of any of our respective countries. So things are evolving, and I think that what socializing means and how trust is built will evolve. And you have a great point here. A great point you made.
Richard, do you have anything to add from your perspective? Have you given it some thought what the world will look like in 5 years? And that will be the final speech, or short speech, because we have to wrap up.
I think we have to wrap up. So all that I can usefully say is the future will be different. No one knows exactly how it will be different. I'm not sure it will necessarily be better or worse, and I'm sure we'll get used to it, and there will still be human interaction, maybe a little less physically, but maybe a little more on the screen rather than in writing. So we may be better off.
So these are reassuring for all of us. The one thing that is sure, there will be another SCAI ASA webinar, and those who are registered will get soon an invitation and publicity on the web. And Caroline Ming also joins us in thanking all those who have attended, and I thank in particular Crenguta and Richard. Thank you very much, and I look forward to seeing all of you physically, hopefully, in one not too distant future. Thank you very much. Goodbye. Have a good afternoon.
Goodbye.
Goodbye.
Thank you.